The main one is that
He did declare it. He did declare it.
Okay. The main one is that most of the courts have viewed this federal government clearly has supremacy in immigration. That's been established by many years of case law. So what Abbott is trying...
Ma'am, I think you might be making an error. The judiciary is actually preceded by the constitutions
Can
and
I
the
just...
law.
Excuse me. You keep
You
interrupting me.
said something that was in error, though.
But you're interrupting me, and I don't agree with you. In other words,
Can you
what you're
just post?
saying...
Can you post the source of what you're using
the
so we
way
can
our
see?
constitutional system has evolved, the judiciary gets to interpret the Constitution, and that becomes what the Constitution is at a given point. Now,
That's
if
what
you
the
want to...
Supreme Court.
The
No. The
Constitution does
Supreme
not
Court just
evolve.
said that was wrong. The Supreme
if
Court just said
if
it's based on a historical analysis and that the
but
government across the country made a
David,
mistake
you're not
and
letting
they
me
did wrong.
continue.
You're
So the...
because you're building facts, but you're not being honest.
Yeah,
I'm...
David, I'll let you break it apart right
Why
after.
don't you
I'm gonna
bring up
let
your
Kira
Okay.
point,
finish, and then you can
Let
break
me
it
get a
apart.
pencil.
No, okay, fine. Get a pencil. Knock yourself out. Okay, so sorry. So basically, since Madison v. Marbury, the Supreme Court has been the final say in our system on what the Constitution means. Now, the court has taken the position recently, but this has evolved over years and it changes, that it's what's within the four corners of the Constitution and what was going on at the time that the Constitution was drafted or the amendments were were ratified that is relevant. But it is still the court that makes those decisions. It will look at the legislative history, it will look at the plain text, and to the extent that there is some in matter of interpretation, it makes that interpretation. And what it says is we're doing this in accordance with the Constitution. But individual people don't make up their own definitions of the Constitution, nor do I think there's something like a Platonic ideal out there, which this is what the Constitution means, because at the end of the day, we're all going to disagree on that. So who makes those decisions? So our system has decided that it is the Supreme Court that will make those decisions. Now, what Governor Abbott is doing, he's saying that the federal government has basically not stopped the state from being invaded. So we have the right under um, Article 1 to say that we can declare an invasion or we can engage in war, is what it actually says, because we're being invaded or in imminent danger. The problem with that is sort of twofold to me, but obviously this has not been litigated, I believe, or at least it hasn't gone up to the Supreme Court. But the problem with that is that in essence, the Supreme Court has ruled for many years that the federal government has primacy in immigration. And what Abbott is sort of trying to do is say, well, it's not really immigration, it's really border security. But at the end of the day, the actions that he wants to take relate to immigration, right? You're not going to let people in, you're going to throw people out, etc. So it seems to me that it's something of a disingenuous legal argument. Moreover, when the courts have been faced with arguments that an invasion is happening in this type of context, hasn't been Supreme Court, but the courts that have considered this has said, nah, federal rules, and this is sort of non-justiciable. We're not weighing into this, but basically the feds rule. So I guess my view of this is, I'm not saying Abbott might not have arguments, but I think the stronger constitutional arguments are on the side of people who say that he cannot just declare an invasion because he wants to. What is an invasion? That's a whole, can of worms. It is basically a group of people coming to the country with antithetical sort of motives to our government. And the thing is, if you look at the people who are asylum seekers, they clearly are not antithetical. They want to be part of our government. So you're really going to have to say it's the drug smugglers bringing in fentanyl. So that's the group of people you're going to have to say are invading. And there is
Can I jump in on that, because you said so many things. I got heat exhaustion a year ago. I might not remember everything.
David, you said a lot too, and I tried to make notes, but ultimately I gave up. So maybe you should do that as well, or
But
make
ma'am,
your notes.
you told
Okay.
several lies. You said
Go ahead,
that
David.
the court actually gets to make the decision on what is right. That is not in the law anywhere. As a matter of fact, the only thing that a court can do is tell what the law is based on the foundational instrument called the Constitution. This is why the government will say in a court case that is unconstitutional. We, the people, wrote the constitutions to frame government for the courts. And if you look up the Black's Law definition of common law, it'll tell you that it derives its authority solely from usages and customs of immemorial antiquity, or from judgments and decrees of the courts recognizing, affirming, and enforcing such usages and customs. So it's not the judges are making the decision and get to interpret. This is what the Supreme Court said that attorneys have been doing wrong for decades.
No,
The
the Supreme
judges can
Oh
only
gosh.
say what the written law is. And you didn't show us any source. You didn't read from any legal dictionary, any authority at all when you said that. I'm giving you the Black's Law definition of
I said
common law.
Madison v. Marbury basically established the fact that Supreme Court was allowed to interpret the
That's
Constitution.
not what it
That's not
said.
accurate.
Marbury versus Madison said that anything that was made that was against what was written in the foundational law called the Constitution is null and void. So when you try to talk about immigration and the courts evolving, that's a lie and a hoax. The courts don't evolve. It is the immemorial antiquity, as I just read you, the law that's been here from the people since the time of the American Revolution. And you're
Listen,
not going to
David,
show
you and
a
I,
single document that says what you say. So please show us. Please.
disagree. You and I disagree
It's
on
not
how
about
the
disagreeing. I'm reading
Constitution
the
is
book. Can you
interpreted.
show us?
No,
Can
no,
you
no.
show
You
us
and I,
anywhere that says that?
let me just, you and I disagree on what the foundational document might say, right?
No, you didn't show it to us.
You
Is
and
my
I
issue.
will
I don't
disagree
disagree
on
with
whether
you.
Texas, for example, can declare an invasion, right? You and
The
I disagree on that.
Constitution says every state, the legislature or the executive can declare an invasion. Is that not what we, the people, gave them permission to do,
It
ma'am?
says they can engage in war if they think there's an invasion.
No,
But
ma'am.
whom,
Article 4,
David,
Section 4 says, upon
David,
application of the legislature or the executive, that is the governor. It's in the text of Article 4, Section 4, and you're purposely omitting it.
yeah,
Why
David,
don't you read the rest of it?
let's let Ben jump in real quick, and then Jared's gonna respond.
I just got a one-liner really, because the Constitution is not subjective. It was made to be crystal clear. And our founding fathers literally made it when when the executive branch is derelict of their duties to protect the United States or the individual state itself. That's why this clause is in here. That's what Section 3 says, or excuse me, Clause 3 of the Constitution. And so it's in Article 1. It's very clear. So there's no room to decide that we want to say that the Constitution is this one day and the Constitution is this the other. There's no argument here.
no,
The
there is a
there's
total argument that you're
no, there
not.
isn't, because
There is, because you're
because
basically
the
saying,
governor of Texas has
listen. What David just said. Here's what Article 4 says: the United States will guarantee to each state a Republican form of government shall protect each of them against invasion. There's a semicolon, so the next clause is separate. And on application of the legislature or of the executive against domestic violence. So
Or
it's not
the
even
executive.
relating to
The
invasions.
governor is
relating,
executive, ma'am.
but
The
yes,
governor
but
is
he would
executive.
have to make an application first, right?
He did. He declared it. That's all you have to do, like the Declaration of Independence.
And then the United States will say there's no invasion.
You notice you didn't admit that part when you spoke about Article 4, Section 4. You conveniently left that out.
Like I said, against domestic violence, I'm not sure. Did he say against domestic violence?
He doesn't have to say domestic violence when the governor has the power.
That's what the
Ma'am, the governor has the power granted by the people in black and white letters that he can say that there's an invasion. Did it not say that?
It says against domestic violence in the clause. I'm not sure what he actually said.
Governor, ma'am. Ma'am, you didn't mention the executive.
Did it say the executive? Against domestic violence. You're misreading it, but it doesn't. Forget it.
Actually, you left it out, ma'am. It just said it.
David, let's just say that you're correct. At the end of the day,
it's not about me, ma'am. I'm not
with you.
What does the document say?
David, you can respond. Let Jared go, and you can respond. Go
ahead. So David, we're disagreeing, and that's part of the thing about the Constitution. People will disagree. I'm reading it as a separate clause saying he had to say, if he wants to make an application, he had to say there's domestic violence, which is a whole different concept, right? You're reading it as no, if he wants to say there's an invasion. We're both reading it differently. There is no, like I said, it's not like the Constitution up in the air and everybody agrees on this. They don't. We don't all agree. That's part of the problem. We would be fighting about this forever. We need people to interpret it, and courts are who interprets it, subject to whatever their particular bents are, which changes over the year. I'm sorry, I don't understand, because if you sit there and say, you're right, I know what the Constitution is. It's immutable. It means this and this and this. And I say, no, it means this and this and this, because it's subject to interpretation, because that clause there does this, or there's a period here, etc. We are just going to fight about it. right? There's not, I don't agree with you that there is just this immutable truth that you alone know, because you
It's
and
not
I
me
are
alone,
disagree.
ma'am. It's written in the text, and the forefathers of law,
No,
who
no, they
all government
didn't.
officials follow, agree
Listen,
with what's written in the
no,
foundational principles,
what,
which you
listen to
haven't brought
me.
up.
If they all agreed, we would never have court cases.
That's not true, ma'am. Attorneys have been taught since 1938, when they came with administrative cases, that they can use a different type of law based on statutory fiat. That's why you're getting this thing where you're calling it precedents and case law. You can't bring things that's derogatory to the common law into precedents. So you're trying to speak about something recent and case law and evolving when the fundamental law says you can't do that. You've been indoctrinated, and I can show you in writing where they did it to you. They tell you they did it.
So
you're
you're saying that there was never a case before the 1930s where the court just interpreted the Constitution in connection with, they have to have a case, right? There has to
ma'am,
be
you
something.
don't have to
So
have a case. You have to have the words that the people
No,
granted.
David,
Ma'am, I can show you in the
we
maxims.
just
Look, ma'am,
disagree
I'll get
completely.
somebody to put it. Look,
Look,
I'll get
we
somebody to put it
disagree.
in the chat
What am I
bubble
going to
right
say?
now.
I will have people who listen to you and they might agree with what you're saying. I think it's nonsense myself. I think the court basically, people bring questions to the court about how do we interpret this, or is this particular statute unconstitutional, or is this state law, maybe does it violate the Constitution? And that is what the court does. We're disagreeing on this. We're not going to resolve this because I don't agree with
But you're
anything you're
wrong,
saying.
because Article 1, Section 10 is very clear that this situation is made in emergency circumstances, where he has the executive authority to supersede any court in any situation where there's a threat to the sovereignty and the people and the safety of the people of Texas and the United States. And that's
And
exactly
I
what happened.
disagree. I'm telling you, I don't think it's
It
clear
doesn't
at all.
matter
And
if you
when
Ma'am,
disagree. It is
it
no,
doesn't
literally
when
matter
clear
cases
what
that
you
cut.
think.
come up,
You're an
that
attorney. You went to law school. You should know
yes,
this. It is
no,
clear cut, black and white.
listen. If when I look at, I've been researching this all day, and when I've looked at people who talk
So you're
about
not
this
a
legal,
constitutional lawyer.
um, I've been researching this
So you're
particular
not.
issue.
Where did
I
you
do
practice
not,
law?
I do not give any information about myself on these
So you're
spaces
not a
because people,
constitutional lawyer. You're not an expert, and you
Define,
have
define,
zero idea
wait,
and
what's
wait,
going on
wait,
in the court.
define
you are
research.
perhaps you
Define
are
research.
perhaps an expert on this, real Ben? Are you?
Define,
Wait,
Yes.
ma'am.
define research.
Real
If
Ben,
you
are
have
you?
research, why didn't you post any fundamental principles of law, any
David,
maxims, anything from the
okay,
authorities? Why didn't you show us anything?
listen to me.
Yeah,
I
what is
we
research in Tara's world?
What is research in Tara's world? I read about
I
five
think you should
cases.
give us
I
full
read every
disclosure,
article I
ma'am.
could pull up, and I already had looked at the Constitution previous to this. But once
What
Governor
part?
Abbott
What
started
part?
making these
What
things,
part? What part of the
Can you
Constitution?
can you
What part?
please show us?
okay,
Can we
you
humble
know what?
ourselves and let you
Wait,
show us
can we?
so we can
Heather,
have full disclosure?
He asked you a
listen,
question. We'll let Tira respond, and then you guys can jump in. Go ahead, Tira.
listen, we're disagreeing, right? I don't agree with you. I think the Constitution is interpreted by the courts. If you look at case law, you'll see that there have been many cases in which, like, for example, a state will do one thing, and the plaintiff or whoever has lost will bring it to the Supreme Court and say, didn't this violate the U.S. Constitution? And the court will then say, yes, it did, or no, it didn't, right? They will make that determination. They make it all the time. They've been making it for many, many years, okay? You're somehow suggesting that there's no reason to bring those cases because we would know the answer, because we somehow know the answer out of thin air. We are disagreeing fundamentally about how this works. Okay. And if you
We
don't,
wrote the Constitution. It's not
no,
out
no,
of
no,
thin
you didn't write the Constitution. The
air. The
Constitution was
people
written by
wrote
the
it.
founding fathers, and you were assuming, once again, that there's an immutable truth behind it. Okay. That is your theory, correct?
Well,
And that everybody
they all
agrees.
agree though.
And that
They all
everybody
agree.
agrees, so we don't need a court to interpret it because it's just obvious.
No,
But it
no.
is.
You said the court uses the constitutionality. We, the people, wrote the Constitution, ma'am. You're missing that. The
No,
government didn't write
David,
it. We
I'm
wrote
not
it.
missing what you're saying. I'm saying your way is anarchy because we all disagree on what it
It's
means. For
not. This
example,
is how America was created. We, the
David,
people, wrote the constitutions. We wrote
David,
the declarations. It was
I'll give
us.
you an example. Many people don't until the Supreme Court actually ruled on this. A lot of people didn't think that the right to bear arms was an individual sort of right. Okay,
Yeah, but
it
it's
was
written in the text.
it was in context of the militia, but that had not been
No,
assumed for many,
ma'am,
many
that's
years
wrong.
because there's a
That's
comma.
wrong.
You see,
That's
that's what you're,
wrong.
but don't you see? You're just saying you're
No, I'm
wrong,
not just
I'm
saying.
right.
Each of
No,
the
you
state
are.
constitutions say that we have a right to guns to protect
You
ourselves against
listen
bad
to me.
government and other things. That's what the
Okay.
state constitutions say. And the first 13 colonies became states and they created the
All right,
federal
Nick,
map.
I,
So
I can't
you're
do this
backwards.
anymore. This is ridiculous. If people don't understand, we have a fundamental disagreement here, and
Can you just
it
show
doesn't.
sources
No,
though?
no, no,
If
no,
you
no.
show, I will agree with you if you show a source, but you're
What
not
Yeah.
showing a
Okay.
source?
All
single
We're
right. Yeah.
not
source.
Yeah.
showing
I agree. You know,
sources.
we've hashed out this issue pretty well here. So I'm